Good morning, Parole Board.
Good morning.
How are you, sir? I am Deputy CT of Orleans Parish Sheriff's Office. I have three gentlemen with me, Mr. Randell Mark, Mr. Joshua Maynard, and I also have Mr. Edmund Sheckbrett. Which one of the gentlemen you would like to see first?
I think we're going to start with Mr. Randell Mark.
No problem.
Good morning.
Good morning. You are Mr. Randell Mark.
Yes, sir.
It's 11:27. Our current location is going to be at Orleans Parish. First case is Mr. Randell Mark. This is a revocation hearing. Mr. Mark, would you give us your full name and DOC number, please?
Randell Mark, RANDELL MARK 444-840.
Thank you. Mr. Mark, you're represented by Mr. Bevinetto. Mr. Bevinetto, if you would please make an appearance for the record.
Good morning, Judge Marabella, Mr. Natsa, Mr. Freeman. Andrew Bevinetto on behalf of Randell Mark.
Thank you very much. Mr. Mark, this is a revocation hearing. I want to explain our procedure to you. I'm going to cover your parole revocation questionnaire. Do you have that before you? Do you have that with you?
Yes, sir.
Okay, we're going to get to that in just a second. Then I'm going to read you the allegations of how it's alleged you violated your parole. You'll have an opportunity to plead guilty, not guilty, guilty with a statement, or not guilty with a statement. And then we'll have a full discussion of allegations. Then you'll have an opportunity to make a statement to us, and at which time Mr. Bevinetto will close and make his case to the board. Do you understand our procedure?
Yes, sir.
Let's go ahead and look at your questionnaire. It appears that on August the 23rd of 2022, you were presented that questionnaire and you signed it. Can you see that today?
Yes, sir.
All of those questions that you answered then are true and correct?
Yes, sir.
And you're prepared today to go forward with your hearing. You are represented by Mr. Bevinetto. Is that correct?
Yes, sir.
And you're prepared to go forward?
Yes, sir.
Okay. I'm going to read you the allegations, Mr. Mark. The rule violations are number 4. You were arrested on June the 25th of 2022 in Orleans Parish and was charged with battery upon a dating partner and a recalled Kenner Police Department warrant. The charges on July 14th of 2022 under magistrate number 598745 were refused. How do you plead to that allegation? Mr. Bevinetto, how do you wish with it?
Yeah, Judge, I would advise Mr. Mark plead not guilty to the allegation.
Mr. Mark, how do you plead to the allegation?
Not guilty.
Yeah. Mr. Mark, your case has been assigned to Ms. Renatza. She will begin our discussion today. Would you please answer any questions she may have?
Yes.
Good morning, Mr. Mark.
Good morning. How you doing?
I'm good. How are you today?
I'm all right.
So I reviewed the information that was provided to us regarding your today's proceedings. So you pled not guilty. I do see where those pending charges were refused, and then you were detained again. You bonded out, the charges were refused, then you were detained again on our warrant for parole violation.
Yes, ma'am.
And that's where you're at today, right?
Yes, ma'am.
The reason I believe the pending charges are refused is I believe the victim chose to withdraw her complaint. As I read through the information provided by your counsel and by the probation and parole officer, I believe that your attorney has worked out a plan that we'd like to hear about. So, Mr. Bevinetto, could you just kind of tell us what what your plan would be for Mr. Mark.
Yes, absolutely, Ms. Renata. Thank you. So the incident itself was refused by the DA's office, as you mentioned, but as I noted in my correspondence to the board, that certainly doesn't mean that it's not possible for revocation. I think the board's probably familiar with the fact that in domestic type situations, I think it's about 80% of the time the victim comes forward and doesn't want the charges to be prosecuted. And, about half that time it's because, they've reconciled and the victim doesn't want the defendant to get in any further trouble. But I think there is a portion of time that there's a situation where the alleged victim, made some allegations that might not be entirely accurate. And I think in this incident with what happened here, I truly believe we have that situation. Now, I'm cautious because Mr. Mark does have a history of domestic incidents. And I think that that's something that the board absolutely needs to look at and consider. However, in this incident, I provided the incident report from NOPD to the board, and it's the allegations were that Miss Morton, who was the dating partner of Mr. Mark at the time, alleges that she went over to an address on Igania Street in New Orleans where he was at, and an altercation ensued. And she alleges that he grabbed her by one arm, grabbed her by another arm, and then grabbed her jaw. And then she called the police. When the police arrive, I think it's worth noting that the officer who wrote that report noted that Mr. Mark made absolutely no attempt to flee. He did not resist arrest. He stayed on scene. He was Mirandized, and he gave a statement. And the statement that Mr. Mark gave on that day, the day of the incident, not after he's hired counsel and, had the ability to come up with a story, but the statement that he gave was that she came over and she was the aggressor and she was, verbally assaulting him, and that he never put his hands on her. That, Ms. Renata and board, that is the story that Ms. Morton told me when she hired me to represent Mr. Mark in this hearing. She came to me and she hired me and my firm to represent Mr. Mark. And the reason she did so is, she said, look, I was not accurate and I did not tell the police the truth that day. We did have an argument. I was going through some mental health issues at the time. I was not on my medication. I thought he was leaving me, is the words that she kept saying. I thought he was leaving me. And I don't deal with that well. And that's something that I'm continuing to work in therapy about. And now I'm back on my meds, and, I'm here to try to help him because I believe that I'm the reason that he's in this situation. Now, having said all that, you weren't there. I wasn't there. We don't know what really happened. But I think that there is some discrepancies with what Ms. Morton told the police that day and with what actually happened. It's also worth noting that Ms. Morton on the day of the incident made an allegation to the police that Mr. Mark took a firearm from her vehicle and threw it into the bushes. And the officer was sure to note in the report that he found no evidence of that, and he didn't find that allegation to have any credibility. So you have an officer, basically going out of his way to put in his report, look, I've got to make an arrest here for a domestic abuse misdemeanor. However, I think that there's some issues and there's some, he kind of went out of his way to make that known. Once Ms. Morton communicated with the DA's office made the decision to refuse. So having said all that, I'm not trying to downplay the Mr. Mark's culpability here, because he does have some culpability, right? He needs to know, and I think he realizes at this point that he put himself in a situation by getting into this verbal argument with this dating partner where he made himself vulnerable. He's backing up time for domestic charges. He needs to be able to better deal with that kind of situation going forward. So I think what we've done is we've tried to put a plan in place where, look, he's done 3.5 months in jail with charges having been refused. So he has paid a price. What we have tried to do is put a plan in place to where if the board would consider not revoking him and putting him back on supervision, we've added some conditions or asked for some conditions to be added that I think would ensure the safety of all parties and would ultimately benefit Mr. Mark to not find himself in the same situation down the road, whether it be with, Ms. Morton or with any other dating partner he might have. So what we've done is we've gone into the 19th JDC and we filed a stipulated judgment where Mr. Mark has agreed to a permanent injunction by Louisiana Code of Criminal Procedure 3601, where he agrees not to contact Ms. Morton, to have no communication with her, to stay with 100 yards away from her at all times, to not go to her place of residence or her place of employment. That is a civil stay away order, a civil permanent injunction that if he breaks, he would have, some ramifications through the 19th. But we're also asking that not just have the 3601 in place, but to make an added condition of his parole, should he be put back on supervision, that he have no contact with Ms. Morton whatsoever. He understands through communication with me that if he were to break that, if his parole officer were to show up and see Ms. Morton's car in his driveway and find her hiding in the closet like I've had in one of my previous cases, that's a violation. He's going back to jail. I think he knows that. I think Ms. Morton knows that. So the other thing that we've asked, and it's asked to be made a condition, and I've spoken with Mr. Mark about, is that he have an added condition that he complete the domestic violence intervention program, one of the programs that is a domestic violence focused program that's approved by the court. We have a number of them that are approved by the court in Baton Rouge. I know that his residence plan is going to be closer to the New Orleans area. So, I'm happy to try to find something over there as well, but I know they exist. But have that as an added condition so that he has to go to classes and has to, be able to learn that, it doesn't take, putting your somebody or not putting your hands on somebody when you're in his situation to find yourself in the predicament that he finds himself in now and to be facing with revocation. So he needs to be able to learn how to better deal with situations and avoid putting himself in those situations where, he could find himself again where he is today. Those are the conditions that we've asked for. And, I think it is noted, and I'm sure y'all have correspondence from Tiffany Eagles, who's a supervisor. I've spoken with her. She is not opposed to having him put back on supervision. So, look, I could talk all day. I think y'all know that. But having said all that, I think that there's a plan in place. I think that this situation in particular, I think it would be just to allow him to be back on supervision with these added conditions. So that's what we would ask from the board. And thank you for your time, and thank you for allowing me to participate in today's hearing.
Yes, sir. And thank you, Mr. Bevinetta, for working with Mr. Mark. Mr. Mark, do you understand do you understand that plan?
Yes, ma'am.
You're agreeable to that plan,
Yes, ma'am.
including the domestic violence prevention program?
Yes, ma'am.
Okay, I have no other questions, Mr. Chief.
Mr. Mark, I think you're winning. Is there anything else you'd like to say? Or you think maybe just being quiet and let us rule is the best way to go?
Take it on, sir.
Mr. Bevinetto, anything else you'd like to say?
Nothing further, Judge. Thank you.
Ms. Renata?
Mr. Mark, I read all the reports, and I do believe the version of the story that's been explained to us by Mr. Bevinetto. My vote today is do not revoke, return you to supervision, add the special conditions that you do enroll and complete the domestic violence prevention program, and added also that you have no contact with Paula Morton. Good luck to you.
Thank you, Ms. Renata.
I concur 100%, and I agree.
Mr. Mark, I agree as well. I think it's a good plan. I think it's something that you benefit from. Mr. Bevinetto, it's always a pleasure to see you, and it's wonderful to have good, professional, well-prepared lawyers come before this board. So thank you very much. Mr. Mark, good luck to you, sir.
Thank you. Thank you all.
Thank you to the board.
Well, thank you, Mr. Lawyer. I think that's the first time watching this channel that we've seen a lawyer really do an outstanding job. And yes, he can talk forever, but that is when he earned his paycheck. Without him, surely he does not get off. I wonder if that data has any truth to it, or if he just pulled it out of a hat. It was 80% of, and don't quote me on this because I didn't write it down, but like 80% of domestic violence, but 50% of that, there's never charges pressed, and then like 40% of that, it was completely fabricated. He gives a scenario. Well, if you came home and she's hiding in your closet, you're still going to jail. It was and who knows in this case what really happened. The lawyer puts up such a good, you can see it going that way for sure. And you just don't surround yourself by a woman that can get you locked up. If you're someone who has a history of beating women, man. But yeah, in my opinion, that was some fine lawyering. Love to hear your thoughts on that.